Okay, folks, welcome to part 2 of the COVID updates. Today's is going to be a little bit shorter than it normally is. We have 2 topics. First one, Chase Beneke is going to talk about sort of how to investigate a COVID claim, things to consider, not consider. The proposed legislation that we talked about last week has not yet been passed. So again, some of these things are going to be hypothetical, but he's going to take you through that. The second presentation will be Josh Kuvion, who is going to talk about the updates with the stay-at-home order extended and how it impacts the current claims that are out there today. For those of you who need continuing education credits, email me with your license number and your state. We are submitting those for you. Louisiana just got approved as well. I think the only state that we're pending approval is Mississippi. I think all the other states, we have approval for these to get approved and to get your CE credit. Chase is going to go first with the investigation techniques and suggestions, and then Josh will follow with the updates on how the impact of the governor's order and some of the more recent case law and blurb developments that we've seen not only in our state but across the country. So I'm going to turn it over to Chase now and he'll get started.
Hey everyone, and welcome. Couple housekeeping notes. I see a lot of you are actually joined as me, Chase Beneke, and what happened, I think, was when the meeting link got generated for this week, at some reason personalize it to me. So if you like, you can always click on your name and rename yourself to your name. If not, don't worry about it, and you can just email John and let him know that you're in the meeting and you came, and that'll be, and we'll make sure you get your CE credit in. Anything else? You said you can rename yourself. If you have any questions, again, just submit them in the either the text, the chat, or feel free to unmute yourself and just ask your question as we go. I don't have a problem with you doing that. So last week we talked a lot about these potential COVID cases that might arise in your workplace, potential employees who might think they've become infected or exposed to someone who was infected. Last week we talked about the compensability of those claims, who would be included as compensable work accident or work injury and who would not be. This is kind of going to deal with how to investigate that. We talked about that the statute, proposed legislation in Louisiana, and how is that going to impact this. As written, it will have a great impact. The way the statute is written now, it is a mandate for coverage for all essential employees for workers' compensation benefits. It doesn't have anywhere in the statute as currently written for rebutting that presumption. We think if this does get passed, they will need to put in somewhere where it's a rebuttable presumption, just like anywhere else for an occupational disease. It would just be a presumed condition for an essential employee. So in that effect, doing these investigations now will be important because that should come into play even if the legislation does get passed, and we'll see if that happens. Right now, the legislature in Louisiana is not meeting. The governor, in his press conference yesterday, said he was hoping the legislature would meet. He said he deemed them as essential employees, mainly because we need to get a budget passed in the state. And so if they do come back to Baton Rouge and meet, it would be interesting to see how they take up this law, if it's given a priority status or not. Right now, nothing's happened to it since it was initially introduced. It's scheduled for rereading, and that is it. So let's talk a little about the investigation. First, you're going to determine the nature of the exposure. You need to talk to the employee and ask, was there an exposure in the course and scope of employment to a coworker or a patient or customer who was confirmed or presumed positive with the coronavirus? So to investigate this, you'll need to ask him, what date did it occur? When do you believe that you came into contact with another employee or a customer or someone who came into the business that had confirmed positive case of coronavirus or COVID-19. You'll need to know who was that person. That way you can do a little bit of our own contact tracing and see, does that person were they really infected? Did they really have a positive test? Or is it just kind of more of a, I heard this guy was exposed and I was around him. We want to see, was there really true contact? Was there really a true method of transmission of the illness between the two people, and whether that transmission happened at work? Which brings us to the next point, is where did exposure occur? What department were you in? Where were you working? When were you working? Where did it physically take place? You know, and that way there are regular investigative things kind of come into play. Was, were you not in the course and scope of employment when you made this contact? Were you at home? Were you outside of work? Were you on lunch? Were you doing something where it wouldn't normally be included? We didn't want to see alternate forms of infection or exposure. Was there exposure to anyone outside of work who was confirmed or presumed positive with coronavirus or COVID-19? You know, did they live with someone? Is their spouse infected? Were they infected before them? Did they have a family member or a neighbor who they may have been around were they infected? If so, you're going to, again, what date did that occur? Who is that person? And where did it occur? And, you know, what you're looking for is, was the person someone we don't have control over? And was it somewhere that we don't have control over that wouldn't be in the course and scope of employment? Next, you're going to look at kind of the actions of the employee outside of the home in order to build a defense that maybe this person wasn't taking the precautions they needed to take to not protect themselves from infection outside of work. And that way we can make an argument, should it come to that, that they were behaving in a way that exposed them outside of work, and that was their likely cause of infection. Jeff, you have a question?
Yeah, so my wife works for the Department of Health and Hospitals here in Louisiana, and they do a lot. I know whenever you have a positive case, they do epidemiology. They go back and trace, where have you been, who are you with, who did you come in contact with. Do you think any of that information would become available from the state if we got into a situation where there was a dispute over whether somebody contracted this at the workplace?
Yeah, I mean, I think if it's something generated by the state, I think it's, you know, discoverable, you know, Freedom of Information Act type request. Maybe it had to be done. If it's something that's within the Department of Health and Hospitals, I think it would maybe be something that would likely be included as part of their medical record, or should be at least. And so it would be something we could subpoena from a healthcare provider, or at least with a HIPAA, get that released. I think that'd be very relevant. It kind of would establish a different chain of infection than one that occurred at work. Yesterday in the governor's press conference here, they were making plans to expand that type of contact tracing. They talked about hiring, determining how many people need to hire. They looked at Massachusetts, who has hired 700 people in Massachusetts to do that kind of work. So depending on population, the way that averages out, they do the same in Louisiana. I think I saw in Georgia it hired 250 people. So I looked at that being something that actually is going to be expanding a lot in the next few weeks or months. And I think that would be something very beneficial once we have these claims, to get that information as best as possible. If they're telling you, I've been infected at work, but then you get their contact tracing and they're telling that person, no, I got from my grandmother or whatever, that's obviously going to be a big defense, and maybe even 1208 fraud, you know, if they're telling different people different things.
I would just think that if you're having this discussion with perhaps say a claims adjuster or somebody of that nature versus, you know, somebody who first initially calls you with a positive diagnosis, you're going to have a different mindset when you're speaking to that person versus this person, which is a more defensive mindset. More
Absolutely.
Truth over here, a little less over here.
Right. You know, which we see that in a lot of claims when, you know, we've all had cases where they're telling the ER doctor who first sees them something totally different than they end up telling you as an adjuster or you investigating the accident. So I would definitely foresee that happening in these cases as well, especially with, you know, dollars and cents on the line.
Got it.
Next is we're going to determine, after we figure out and do like our own contact tracing and hopefully get that information as best possible, we're going to want to determine what the infection or treatment status is of the employee. What day did they first start having the symptoms? We talked a little bit about this last week. We're learning more and more about the virus. And it's kind of, you know, they say one thing one week and kind of learn new things the next week. And one day I think they'll have a consensus about this, is the timeline and the lag between the infection and when symptoms first start occurring. It's different for all people, of course, but if a person saying, I first had symptoms this date, and you look, they were off work for the last 2-3 weeks, they're on vacation 2 weeks ago, that is going to, of course, give a potential different defense. So on what day they start having the symptoms, you're going to want to obtain a timeline of when and where they worked around during the onset of symptoms, and a list of who they worked with during the onset of symptoms, and probably, in a few weeks prior to that as well. If they've been tested already, you want to know when was the test performed, where was the test administered, what were the results of the test, of course, and when did they receive those results? Did they receive those results and keep working and potentially expose other people? Even though that wouldn't be much of defense from a comp perspective, it could, give us some information on those persons' future claims. Then this for purposes of investigating compensability and exposure for medical benefits, you're going to want to know where they've been treating, were they ever hospitalized, of course. And I think that's something we probably know, but and when they treated, and for how long they've been treating. This could all come into play not only in obtaining those medical records to investigate what they're saying about causation, but also taking a look at the duration of treatment and getting a feel for exposure for benefits. We talked a little bit about last week the difference between compensability for people in different fields of work. We already feel that frontline workers, healthcare providers, those type of people are, regardless of any statute is going to pass, they're going to be looked at under the existing occupational disease statute is a person who, due to their particular trade, is exposed to this virus and would be considered an occupational disease. So learning where they at least have been treating is going to be important for moving their claim along, which Josh will talk about that a little bit later, at least in managing claims in general. The next thing you want to do, it kind of leads back into the first thing, is further investigation regarding different potential alternative sources of infection. If they were sick back in March or even early April, you want to know if they lived down here in South Louisiana, did they go to Mardi Gras? How many days were they in Mardi Gras? Where did they go? Who they were with during Mardi Gras? If they didn't go to Mardi Gras, were they at any other big events? Did they go on any cruises? Did they go on vacations? Did they travel outside the country? These are all potential outside sources of infection, which could be potentially used as a defense to compensability. You're going to know where they traveled, when they traveled, by what method did they travel? Did they travel by airplane, cruise ship in particular, and how long were they gone? And I think we probably need that information from February 1st to the present, since that's when they think the virus in this area probably first started circulating. And I think as more evidence comes out, I'll probably move that timeline back. Also, we're going to want to know about, were they in the hospital for any other reasons since February 1st? Did they visit any nursing homes? Did they visit any long-term care facilities? And you want to know, when did they visit those facilities? Where did they visit? Whether it was for their own treatment or to visit loved ones or friends. These are all going to be potential outside sources of infection that could be beneficial. If you get all this information, the next step is going to be digesting it and determining what claims may be compensable or not. Again, depending on how the statute gets processed through the legislature, it's going to have a big impact on that. But at least operating under our current occupational disease statute, which we talked about last week, if it is determined that the employee, or alleged at least that the employee was exposed to work, whether to a coworker or a customer, and they are having symptoms, which would include, fever, cough, shortness of breath, or they have tested positive for COVID-19, you should notify the carrier if you're in that position, or probably open a claim. If it is determined that they were exposed at work, and that's, for a fact they were exposed at work, and they have then tested positive, and they've been directed by a healthcare provider to quarantine, they will presumably be entitled to the benefits we talked about last week under the CARES Act, but also likely to workers' compensation and indemnity benefits for the duration they're prevented from returning to work, whether due to the quarantine period or due to them actually being disabled as a result of their infection. Again, generally the first installment of compensation is payable for TTD on the 14th day after there's knowledge of the injury. So once they put you on notice, they're having an infection, technically that time period will start. However, again, this is going to be impacted by the CARES Act. Again, if you weren't here last week or you've forgotten, the CARES Act provides that covered employees are entitled to 2 weeks or not more than 80 hours of paid sick leave at the employer's regular rate, employee's regular rate of pay. That's going to be up to $511 per day or $5,110 total. Where the employee is unable to work because the employee is quarantined pursuant to a government order or the advice of a healthcare provider, or they're experiencing the COVID-19 symptoms and seeking a medical diagnosis. So that second part kind of broadens that substantially. Again, that would be for the first 2 weeks, but then after that, workers' comp would take over for the compensable claims. We talked about this last week. Is our position that the person would not be entitled to double dip. They're going to get both workers' comp and CARES Act during this time. But once the CARES Act kind of runs out is when comp will take place. If you do all this investigation we talked about and it turns out, yeah, your employee has COVID-19, but their wife had it or they were exposed to a friend who had it outside of work, the employee would still be entitled to the CARES Act, but obviously once the CARES Act benefits ended, they would have to go on their regular PTO, and workers' compensation benefits would not attach. And in those cases, we'd probably follow your regular protocol for denial of a claim, whether it's filing a 1002 form, controverting the claim, or sending out the denial. And it'd be up to them to press their claim, just like any other denied claim. Again, this is a fluid situation given the way the statutes are up in the air. We've seen other states act on this already. Kentucky, for instance, the governor there issued an order that talked about creating a presumption for entitlement to workers' compensation benefits that is, rebuttable for the frontline workers and essential employees. I think personally, if Louisiana acts on this pending legislation, ours will probably look more like that and hopefully not be passed as written, because that would be a pretty substantial departure from the rest of the statute. Anyone have any more questions on this before I turn it over to Josh? All right, John actually wants to say a couple things about handling.
So the two things that I think are the most important to take away from this, in the 30 plus years that I've done this, there's only one presumption, and it's in our favor in the compact, and that is with intoxication. And for those of you who are familiar with it, essentially, once somebody tests positive pursuant to a drug test, it is presumed that they were intoxicated at the time of the accident and that the intoxication caused the injury. Think about how many people are able to get out of that. It is a very hard presumption. We either win those cases on summary judgment or we dismiss them for a very small settlement, for a nuisance value settlement. If the statute is proposed passes, it is a significant change in the law. Right now, I feel like for somebody to sort of present their burden of proof at 51% or greater, the fact that this virus is out there, you can get it from the store, you can get it from friends and family members, you can pick up an item, it lasts on inanimate surfaces. That's going to be a hard burden of proof for me with any infectious disease specialist as the law is. As I understand it today, my advice, and what I've told many of you already, is that unless somebody can prove more probable than not, which I believe is a really uphill battle with the state of things, I feel like we would win on those. If this statute passes, and our firm will be opposing the statute actively, is it will be presumed that it is compensable, and we will have to show a negative. You have to prove a negative that it is not compensable. That is going to be almost impossible to do, again, without retaining an infectious disease specialist. I would suggest to you that the price of an infectious disease specialist after this happens is going to be unbelievable, assuming you could even get somebody to do it. The second thing that concerns me is that the government is taxed to the max. So the logical thing is to pass this on to private carriers and business, because they have sort of given all these stimulus packages. The way to do that is to push the burden of COVID onto the carriers and to employers, and this statute is a vehicle by which, in my opinion, that's what they're doing. They're trying to make COVID a private issue and a private funding, as opposed to something that would be covered by Medicare or Medicaid. So just an FYI, those are my just two observations after having living with this for about a month and a half. I'm deeply concerned about the act, and I think, we will do what we can to get that changed. Whether that's doable or not remains to be seen, but again, these weekly calls will keep you updated. Right now, as Chase said, the legislature is not in session, so we don't have anything to worry about. But again, just to emphasize today, the 51% more probable than not remains in effect insofar as the investigation of current claims until we advise otherwise. I'm going to turn it over to Josh now, and he's going to start with the update on the impact of the governor's order.
Hey, everyone. Before we get started, I'll go over some numbers that came out today at noon. There were 218 new cases reported in Louisiana with 61 new deaths. The new reported cases are down significantly from where they've been. As we know, the deaths are kind of lagging on what's actually occurring out there. That's more representative of what was happening weeks ago. Hospital intakes and ventilator patients were down again today. We are currently up to 1,758 deaths and 27,286 total cases in Louisiana. The United States passed 1 million confirmed cases today. That's roughly a third of all the cases in the world, and we're up over 56,000 deaths in the United States. As everybody is probably aware, or at least the local folks, John Bel Edwards extended the stay-at-home order yesterday until May 15th. That keeps the current social distancing restrictions in place, limits social interactions, limits what kind of businesses can be open. There are 3 changes that he made to the order. The first is that although malls will remain closed, the stores can now deliver curbside to people who order online or call in. He clarified that non-essential retail stores have never been closed, although they still need to limit the number of people inside to 10 or under and make sure that social distancing is being practiced in there. The second change, restaurants can open their outdoor seating. However, they cannot do any tableside service. They still must be takeout only. And the patrons must still practice social distancing. And the third one is that masks are now mandatory for all employees who work in an industry where they are required to interact with the general public. He made sure to note that masks are being recommended whenever anyone goes out in public, but it's now mandatory for those employees. For anybody who falls within this category, I would strongly recommend compliance with that. The COVID-19 claims that are deemed compensable as contracted in the course and scope of employment would be, and this is specifically included in the pending statute, would be subject to the exclusive remedy, meaning that the employee who contracted it would only be able to sue the employer in workers' comp. They would be barred from pursuing any tort claims. However, there is an intentional act exclusion to that. It is a very high burden to prove an intentional act. You have to be substantially certain that the outcome is going to happen. There is a case in Walmart that's been filed by an employee who contracted it in the course and scope of their employment and died. That's a tort case based on negligence that would be barred for a workers' compensation claim here. However, you certainly don't want to give the employees any additional causes of action or ways to pursue a claim in tort. Governor Edwards said that we are potentially looking at phase 1 beginning on May 15th, which will lift the stay-at-home order but keep pretty significant restrictions in place. Some other stores and businesses would be able to open at reduced occupancy. He anticipates giving an update on May 11th on that. New Orleans is under their own stay-at-home order through May 16th. The mayor has said that the changes to the stay-at-home order that were issued by Governor Edwards do not apply to New Orleans. They are operating under the same stay-at-home restrictions as they have been. As of April 27, physicians could begin performing non-emergency, time-sensitive medical procedures. That definition is fluid. But we are starting to see some people getting back in for surgeries that had been delayed and canceled due to the current restrictions. The courts, workers' compensation courts remain closed until further notice. We do not have an anticipated date on them opening. They are approving full and final settlements via email. Each district has been assigned a judge to handle that. They were not doing this previously, but we were informed today that they are also now processing paperwork. So 1008s being filed can now be served. Other orders that are filed, dismissals of 1008s, motions, those can now be processed. Although obviously we won't be having any hearings while the courts are closed. Pro se settlements with unrepresented claimants are also proceeding via video conferencing with Judge Bishop out of Harahan. Any trials set while the court is closed will now be converted to a telephone conference to pick a new trial date. As we talked about last week, any trials that have been continued or canceled already are going to be reset on an expedited basis once the courts reopen. They are also now encouraging that mediations take place via telephone. We have been contacted numerous times today to reset mediations that were previously canceled. In state court, there are no jury trials through June. Other hearings are canceled as well. In the United States Court for the Eastern District of Louisiana, jury trials and grand jury proceedings are suspended through July. Any other hearings that they have, the parties are advised to contact the court. As Chase mentioned, the new proposed legislation, there have been no updates on that since last week. It's been read in. They are waiting to read it into the legislature a second time. There's really been no discussion on that. But given the importance of that, we're certainly monitoring it. And if anything comes up, we will be letting everyone know. There has been very little litigation with respect to the current COVID-19 situation, particularly in Louisiana. As I mentioned earlier, there's been a case filed in Illinois for a negligence claim for a death case. Here, most of the cases have been regarding inmates attempting to get an early release from prison under the Attorney General's COVID program, which is encouraging early release for nonviolent offenders who are older. And for those in New Orleans, you will have seen today that our former mayor, Ray Nagin, was released early from federal prison about 3 years early under that program. There is one case out of the Eastern District. It is SAPS LLC v. Easy Care Clinic, Inc. In that case, the plaintiff filed a motion to quash a corporate representative deposition that had been set, arguing that it should be postponed until travel restrictions and social distancing measures were lifted. The court said that the court reporters can properly administer the oath via video as long as they can see the deponent and hear the deponent. So given that, they denied the motion to quash and said, you can go forward and do this deposition via video conference. We have done multiple depositions in the last few weeks in an effort to move claims along, both with claimants and physicians via video conference. It's really not that different of a process. The other new case, this is another one that came out of Illinois. A state legislator filed for a temporary restraining order on the 30-day extension of their stay-at-home order. And the court granted that, but it only applies to him. So it remains to be seen how that's going to be pursued by the remainder of the citizens, whether that's going to apply to anybody else, and whether any other citizens of any other states are going to pursue that. But that's something to keep an eye on. That's it for the updates. We talked a lot last week, and Chase talked earlier today about handling COVID-19 claims. What we haven't talked about is handling non-COVID-19 claims within the context of the COVID-19 environment and the stay-at-home order and the inability to get into doctors' offices and perform surgeries, and how that would impact how you're going to handle your claims presently. I've got a few issues that I've identified that I think are pertinent at this time. The main one that I want to talk about is employees who are under work restrictions and who are now no longer able to work due to either businesses closing or the position no longer being available due to some restrictions related to COVID-19. And we've got a few different classifications of employees within that. The first one is the employee who is restricted from full duty work, but who has either returned to work at their job of injury and or is capable of earning over 90% of their pre-accident wages. There are a few cases from the past that centered around Hurricane Katrina, which is really the only comparable situation that we can think of where something like this would have applied, where there are mass closures and positions being terminated. The first one that we identified is Poissonneau v. St. Bernard Parish Sheriff's Office. That case involved a deputy who was working at a juvenile facility, and he sustained an injury, but was restricted from full duty. He had permanent medium duty restrictions. Now, under those restrictions, he was capable of returning to work at his job with minimal accommodations. He was able to keep making 90% or more of his average weekly wage. His hours didn't change. His pay didn't change. And this was an injury that had occurred prior to Hurricane Katrina. Once Hurricane Katrina hit, all of the deputies were furloughed, including him. And he argued that because he was under restrictions and he was now unable to earn 90% of his wages, that he was entitled to supplemental earnings benefits. The Workers' Compensation Court initially agreed with him and granted him benefits. The Fourth Circuit Court of Appeal also agreed and affirmed the ruling. So this went up to the Supreme Court. The decision was issued in January of 2011. And the court said that the lower courts had applied the wrong standard. The standard is whether the employee is unable to earn 90% of his average weekly wage as a result of his injury or disability. And in this case, he testified that he would have continued working in that position had he not been furloughed. He was capable of working there. He had been earning 90% of his wages. The only reason that he was unable to do that was because of the closure, which was something beyond the employer's control. So the Supreme Court said that, yes, while he was permanently restricted to medium duty, the inability to earn wages was not as a result of his injury, and he was not entitled to supplemental earnings benefits. There are two other cases out of the Second Circuit Court of Appeal, one which was issued prior in 1999, Taylor v. Columbian Chemicals. This is a similar situation where somebody had injured his knee, he had gone back to work, he was making 90% of his wages, and then the plant closed down. In that case, the Second Circuit found that, as the Supreme Court did in the Poissonneau case later, that the inability to earn wages 90% or greater was not a result of the injury, and he was not entitled to supplemental earnings benefits. And then finally, in Patterson v. General Motor Companies, a case that was decided a few months after Poissonneau in August of 2011, somebody working for GM had been injured. Plant eventually closed down. This person was one of the layoffs, and the restrictions had been accommodated. They had continued to work, earning 90% or more. The person complimented GM on always accommodating their restrictions. And the court, as in Poissonneau, said that the inability to earn 90% was not the result of the injury, but was a result of circumstances beyond the employer's control. So where does that leave us now with employees that were working, were earning 90% or more of their average weekly wage, but were not technically at full duty? If the inability to return to that position is not the result of the injury and is the result of some closure related to COVID-19, or the business being deemed non-essential and subject to the closure, we do not feel that these people would be entitled to supplemental earnings benefits in accordance with the case law, and they should not be paid. In other circumstances, let's look at an employee who is earning less than 90% of their average weekly wage and have been. So they have been being paid supplemental earnings benefits, but they've been able to work in some capacity. Well, at that point, they have established that their inability to earn 90% of their average weekly wage is a result of their injury. So they would continue to be entitled to supplemental earnings benefits. If, for instance, the employer for whom they were injured is offering them a modified position, but they're not making 90%, and then that position cannot be offered anymore because of COVID-19 or a layoff or whatever reason, these employees would remain entitled to supplemental earnings benefits. And in a case where an employer is offering the light duty, we believe that there would be no credit for the wages that were being earned in that light duty position before the closure. So if they're unable to find any other employment, they would be entitled to supplemental earnings benefits at a $0 wage earning capacity. The other situation is employees who have gone through the vocational rehabilitation process and their benefits have been modified based on the positions that have been identified there. So we'll use a hypothetical employee who is restricted from returning to work at their job of injury, and they go through VOC and they identify numerous positions at a minimum wage earning capacity, which are then approved by the physician and confirmed available at the time the employee is notified. Well, under the statute at that point, the employer can take a credit for the wages that the employee would have been able to earn in those positions and modify their benefits accordingly. Regardless of whether they apply or not, as long as you can show that the position was available, it was within their restrictions at the time they were notified, then you get a credit for that wage earning capacity. If this had occurred prior to those particular positions possibly no longer being available because of COVID-19 or layoffs or non-essential closures, we do not feel that this would impact the ongoing entitlement to the credit for the wages they could have earned in those positions. It's a little different than the cases where an employee is working light duty. with the employer with whom they were injured. In the vocational rehabilitation setting that I just discussed, there's no ongoing requirement that the employer or vocational rehabilitation continue to confirm that the position remains available. Once it's available and it's approved and they're notified of it, then the credit applies. In another situation where somebody's working for the employer, the obligation remains to continue to provide that person with a modified duty position. In any of these circumstances where an employee is no longer working because they were because of a layoff or whatever reason, the employee who is restricted from returning to work full duty, there is a credit of a week for week for any unemployment benefits that they receive. So if the employee who is working but not earning 90% goes and applies for unemployment and starts receiving unemployment, then they would not be entitled to workers' compensation benefits in addition to that. However, they could be entitled to workers' comp based on the scenarios that we had just talked about before. Some other issues that have arisen in handling of these non-COVID claims in the current setting is the governor's order suspends the ability to suspend benefits for failure to attend a second medical opinion examination or an independent medical examination. Lots of these have been canceled. If someone objects to attending one, especially the older claimants, which we've had, which we've been experiencing over the last few weeks, there really is no recourse in order to force them to attend so long as the stay-at-home order is in effect. So the question becomes, what do you do? There is the option of either a records review only or a telehealth second medical opinion evaluation. Unless it's something that is extremely time sensitive, I would not recommend either of those. In Louisiana, the treating physician is already granted more weight than the second medical opinion evaluation physician, one who is seen as only seeing them on one occasion in order to provide an opinion for an employer or insurance company. So if an SMO does not actually physically examine the patient or see them face to face, I think the treating physician is going to be afforded even more weight if their opinions differ. The IMEs, the courts are really not setting them right now. They're trying to reset everything for when they anticipate this is going to open up and it's going to be safer for people to attend in-person examinations. In the interim, we're still applying for IMEs and we are still setting SMOs and leaving it to the claimant to object to their attendance or the SMO themselves to cancel. There are significant cancellation fees that apply to both of these. So if you have any cases where there's a possibility that someone may not attend, I would recommend sorting that out sooner than later because we have been getting some bills for those. Another issue is someone who has been referred for a functional capacity evaluation, but either the claimant or the provider are unwilling to perform the examination. If that is occurring until it's deemed appropriate for them to go in under the governor's orders, we would recommend, depending on what the employer has available for light duty, going to the physician and getting an opinion on what they're capable of doing pending the FCE, which would provide a more permanent outlook of their restrictions. If you're looking at voc rehab after an FCE, it's probably a waste of your time to do this. The voc market, and the jobs being identified in labor market surveys are pretty slim right now due to the amount of businesses that have closed and the restrictions on what people can and can't do. So if there is the ability to offer someone light duty with the employer of injury, that is likely going to be a much easier and cleaner method to reduce benefits in the short term as you wait for an FCE and potential permanent restrictions and getting voc rehab involved. There have been some issues with physicians refusing to set rehabilitation conferences. Nurse case managers have been trying to get this done. Most of them at this point would be conducted via telephone, but in that context, a lot of these physicians have not even seen their patients for the last month. So I think a lot of that is on hold. It certainly doesn't stop you from trying if you have an opportunity to bring someone back on light duty. But again, if it's more of a permanent situation, you may be better served from a cost perspective to save your money on that for when things reopen and the physicians can give a better opinion on that. Physical therapy and home exercise programs. I have heard of a few claimants who have told me directly that they were discharged from physical therapy with no real instructions on what they should be doing at home when they're going to reopen. Thankfully, neither of these people were in a post-operative setting where you've got somebody with a knee or a shoulder surgery, and those first few weeks and months are imperative in regaining strength and range of motion. So if you have anybody in those settings and the physical therapy providers are not open, you need to make sure that either a nurse is involved to coordinate a home exercise program, or that you directly make sure that these people have set instructions on what they need to be doing to continue their physical therapy at home to prevent any delays or permanent deficits in their recovery. For those of you who have dealt with patients with shoulder injuries, they develop frozen shoulder, and additional surgeries are required, and the cost of the claim increases exponentially. One of the last things, we've been getting a ton of emails from claimants and claimant attorneys saying that they're not receiving their checks timely due to delays with the mail. If there are direct deposit options, I would encourage you to do those. Otherwise, just keep doing what you're doing. There's no obligation to change your mailing requirements in order to get checks out to people who are receiving indemnity benefits. Are there any questions with respect to the issues that we've just talked about with the potential complications in non-COVID-19 claims that are occurring in the current setting, or just any questions in general on what we've presented today? Feel free to speak up or type your questions into the right. I've got a question here about the state legislator and the stay-at-home order, the one from Illinois. This is something that came about today. I believe he challenged the order on constitutionality, and the temporary restraining order indicated that this particular person was not required to abide by the expanded stay-at-home order, which had been extended for another 30 days. I had not seen the order itself or the rationale of the judge who issued that, but I wanted to make everyone aware of the types of cases that are being filed around the country, including that one, because we may see something like that come down the line, especially if there remains a disconnect between what the governor is issuing and what the mayors, and particularly the mayor of New Orleans, is doing in their areas.
Okay, folks, that's it for today's presentation. Again, reminder, email me your license number and the state that you need credit for, and then I'll do like last week and give you the certificate of participation. The calls will continue for the next 2 weeks or until this stay-at-home order is over. We will continue to have a section like Josh did today, basically updating you with the most recent impacts. Today, I spoke with several of you personally. The courts have sort of communicated with us that they're going to get started via phone and via Skype and Zoom hearings and communications. So I'm sure by next week we'll have some updates on what that means for our cases. If there are topics that you want to see covered, I know one for next week is the impact on maritime claims, on Jones Act and Longshore claims that the firm handles. That may be part of it. There will be 2 more topics. If you have suggestions, we certainly welcome them. Thank you for participating, and stay tuned. Thanks, guys.